A wild story out of Ohio, and I promise you have not heard one like this before. A woman, her husband, and her 4 lovers, yes, 4, are all behind bars after police say they kidnapped, tortured, and held a man captive for an entire week. According to authorities, these lovers, who reportedly share multiple children, beat the victim relentlessly, barely let him eat or drink, and forced him to stay awake for days. And the mastermind behind it all, police say, is Martina Jones. I'll break down this bizarre case for you and walk you through the details. For Law and Crime News, I'm Kennedi Walker. Really quick before we get into the story, I wanted to announce the launch of our Law and Crime YouTube membership, a new program we launched to give you exclusive perks like custom emojis and badges, along with members-only live streams where you can chat with your favorite Law and Crime hosts and guests. There are 3 levels of membership: armchair detective, amateur attorney, and honorary judge. Each level has different perks that you'll love. So go check each level out and choose what works best for you by clicking the link in the description and becoming an official Law and Crime member today, or click the join button under this video. All right, back to the story. Polygamy usually brings to mind a man with multiple wives, but in this case, we're talking about a woman with multiple partners and a criminal case that's anything but ordinary. Meet the so-called family: 28-year-old Martina Jones, her husband, who's the same age, Michael Esqueda, and boyfriends: 26-year-old David Cessna, 27-year-old Chance Johnston, 49-year-old Aaron Bradshaw, and Austin Bradshaw, who's 28. At this time, it's unclear if Aaron and Austin Bradshaw are related. All 6 were arrested on March 22nd. So how did we get here? Well, let's rewind to March 14th. Court documents allege that Jones, her husband, and her lovers kidnapped a 26-year-old man and held him against his will for a week. According to an interview given by Maumee Chief of Police Josh Sparrow to WTVG, during that time, the group allegedly beat the victim repeatedly with their fists, elbows, and even a metal baseball bat, forced him to stand for hours at a time, deprived him of food and water, only allowing him to eat just once a day, and kept him awake, limiting him to just 10 hours of sleep during the 7-day span. Police say the victim was moved between 2 locations, a Red Roof Inn and a Toledo home. But on March 21st, the alleged victim finally saw an opportunity to escape. According to court documents obtained by WTVG, his alleged captors took him to a convenience store where he managed to get a message to someone inside. That person, assumingly realizing the urgency, reportedly called the one person who wouldn't hesitate to take action: his mother. And she did just that. Police say the victim's mother sprung into action, racing to the motel where she believed her son was being held. Moments later, Maumee police arrived after receiving reports of a disturbance. And that's when the alleged polygamous crime ring came crashing down. Officers arrested all 6 suspects, bringing an end to what police describe as a week-long nightmare. The alleged victim is expected to survive. Right now, it's still unclear how the victim knew his alleged captors or why he was targeted. But one thing police say was crystal clear: Martina Jones was reportedly the one in charge. Investigators claim she orchestrated the kidnapping and ordered the brutal beatings, directing her husband and 4 lovers to carry out the assaults. Now, Jones, Esqueda, Cessna, Johnston, and the Bradshaws are all facing charges, including 1 count of kidnapping, 3 counts of felonious assault, and 2 counts of tampering with evidence. With these charges carrying significant prison time, this unconventional love affair may soon turn into a lifetime behind bars. Joining me to talk more about this is former Judge Fanon Rucker. Thank you so much for coming on. Let's dive right in. What kind of prison time could each of the 6 suspects face if convicted?
Well, so there's 2 ways that these sentences can run. They can run concurrently or they can run consecutively. Now, as far as years, kidnapping itself as a first-degree felony generally carries 3 to 11 years in Ohio. The felonious, it's a first-degree felony. The felonious assault charges are generally second-degree felonies, and they carry about the same time, 15 years, if using weapons involved. I mean, we're talking, decades that these people could potentially be facing if the judge runs these sentences consecutively, if they are in fact convicted.
What about if they take a plea?
A plea in this instance, and pleas can run the gambit. In Ohio, it is up to the judge to sign off and accept the plea once the parties agree to it. But you know, the we have something in Ohio called Marcy's Law. A lot of other states have passed it over the past 10 years that allows the victim the right to have a say in the proceedings of the case. They have the ability to be there at every stage of the proceedings. They have the ability to offer their position as to whether or not a plea should and would be actually even granted. And ultimately, at sentencing, the victim in Ohio has the right to give their input. So when we talk about a plea can only be entered into if the prosecutor makes an offer, and they're going to be real careful with the nature of these offenses and the nature of the allegations, with allowing the victim a significant amount of say so in offering pleas to these defendants who did these outrageous and heinous acts to this individual, because what we know is that the paramour involved in all this actually lied about how she even got injured. But a plea could be anything from dropping the heaviest charges, allowing them to plead to assault charges, aggravated assault, which would only carry a couple of years each, or it could include merging the lower offenses and having them plead to the most serious charges, probably of kidnapping or the felonious assault charges, and they agree to something between 4 and 7 years. But again, it runs the range, and there's no way to know the prior criminal records of these individuals, the interests of the victim, whether the judge would even accept it based on the allegations, or if the victim would be inclined to agree to let these folks do something less, considering what he went through.
What challenges do prosecutors face in trying a group of defendants involved in the same crime?
Well, there's a couple of ways that these cases can be tried. Individually, each each defendant can have a separate case in a separate courtroom before a separate judge. Or there are times when all the defendants are tried together. Now that's a very rare occasion, because you do have individual circumstances and backgrounds and histories and actions of the individual defendant. What most likely happens is they look at the actions of all five of the persons involved, and they go to one of them and say, "Hey, look, we think that you had the least amount of culpability. We know you got talked into this. We know you were encouraged to do this. You were threatened in order to get involved. So we're going to offer you the ability to plead out to a lesser charge, get probation, as long as you testify to these other people's actions, because you really need that to ensure that you have a strong case that somebody who was part of it actually turns and tells on the others who were actually involved." And that can be a difficulty for the prosecution, is figuring out which one to offer a plea to, offering the right plea to encourage them to testify, and then, making sure that they're truthful and credible when they go to trial if the others decide they want to challenge the charges that they actually are facing.
Could the alleged polygamous relationship impact the case in any legal way, or is it irrelevant?
There's one husband and wife circumstance, and that's the actual woman who's at the center of this and her husband. And so there are certain immunities that apply, or there's certain prohibitions on the requirement of having either of them testify against each other. It's called spousal immunity. A spouse cannot be compelled or forced under the law to testify against their spouse. However, the fact that these other three men are involved in some type of relationship, they're not actually allowed to claim the spousal immunity that prevents them from being testified against, or prevent the others from testifying against them. So the polygamous nature of it may go to motive. It may go to the salacious nature of the facts itself, where the jury is sitting on the edges of their seat while they're watching. But from a legal standpoint, the only ones who are actually impacted by the nature of the relationship are the husband and the wife.
In this case, police are claiming the woman was the one in charge and allegedly she was the one calling the shots. So, could a plea deal be on the table for any of the suspects that aren't legally married to her in exchange for testimony?
They can offer a plea deal to the husband. Again, he can't be compelled to testify, but they can offer him a deal. If he testifies, he's mad about the fact that his wife had these other folks and he really didn't want to do it. So now he's like, you know what, I'm going to go ahead and testify. The spouses can waive the privilege. They can't be forced to do it, but they can waive the privilege. So can a plea deal be offered to these individuals or to the husband and wife to testify against the others? Sure. Before I was a judge, for a very long time, I was a prosecutor for almost as long as I served as a judge. And one thing that I can tell you from almost 30 years of practice and still going in and out of courtrooms is that truly the singular most powerful individual in the court system when it comes to criminal cases is the prosecutor. I mean, the prosecutor decides what charges are brought. The prosecutor decides whether and to what extent there are plea deals. And they decide the level of advocacy they make for the consequences that people may actually encounter if they are found guilty as they go through the system. The judge actually, of course, we had a whole lot of power to do things, but the prosecutor has a whole lot of discretion, and the exercise of that discretion is a demonstration of the weight of the power that they have. So what type of plea deals? It can be as broad as probation being offered to I don't like what you did. We have enough evidence and somebody who's going to testify against you. So we'll drop one half of one charge and you got to plead to the rest of them. Take it or leave it. I mean, that's the weight that prosecutors hold when it comes to the cases that they present and that they represent and advocate for.
If Martina Jones is found to be the alleged ringleader, what additional charges could she potentially face?
She can be, and anytime anyone is involved in an incident where there are a combination of two or more individuals who have agreed and who have consulted and acted in concert to commit a crime, there's a conspiracy charge. And the conspiracy charge is the same as the offense of the principal itself. So even if she didn't show up at that hotel room and engage in the torture that this individual was subjected to, her advising, encouraging, motivating, supporting, or assisting these individuals in committing that crime would subject her to the same penalties that they have for the injuries that he sustained, because she was the at the center and really perhaps the person who encouraged them to do this to this individual.
Could the defense argue that Martina Jones wasn't the mastermind and that another suspect was in charge, especially if it's found that she didn't hurt the victim herself?
I suspect that a good defense attorney in this case would argue that the most that she did was told her paramours what was going on, but she didn't know, she didn't encourage, she didn't tell them to go do something to him. That would be what a good defense attorney argues. I was just telling them, what happened to my arm, and and they decided on their own that they were going to go and hurt this guy. But you kind of wonder with the nature of the intermingling of their relationships, whether she would fall on the sword or they would let her fall on the sword and get out of this with the lesser consequence. They seem very wrapped up in this individual, and they don't want anything to happen to her. I don't know.
Well, how does Ohio law define kidnapping, and what must prosecutors prove to secure a conviction?
On a kidnapping, essentially what you're proving is that someone against their will was removed or restrained from leaving. There's a fine line, or there's unlawful restraint, which says you didn't let somebody leave or you kept somebody from going somewhere. Kidnapping is a bit more aggressive. It's where a person is conscious that they're being confined and that you restrict and purposely keep them from exercising their freedom of movement. There's enhancements for kidnapping where it's being done for the purpose of committing criminal offenses or to inflict harm, which of course that's what we have here, which would take this to the higher end of the potential consequences.
Since the victim was allegedly moved between locations, does this make the case more aggravated?
Well, what makes it more aggravated is the reason that they actually moved him to another location. The fact that he was moved or confined in his space, that's the kidnapping itself. But the purpose of and what they did once they removed him or kept him confined is the aggravating circumstance that makes this penalty much more significant.
I know we talked about a potential defense strategy for Martina, but what legal defense strategies could the other suspects use in a case like this?
As a former prosecutor and judge, it's hard to see what defense they would have, knowing what the allegations are. And certainly, it's difficult for us when we see news stories and when we hear from lawyers in 30 seconds clips talking about their clients, because what we don't know is what evidence the state have. We don't know what evidence they collected. We don't know what witnesses may have heard something going on, who perhaps were in next door hotel rooms and heard the screams and the yells or perhaps saw a car driving away. We have no idea what they have. So it's difficult to know what the defense strategy is. Overall, looking at the nature of the charges, the state is required in every offense to prove their cases by proof beyond a reasonable doubt, which is the highest standard that we have in our legal system. Essentially, a good defense attorney is going to say, look, state, prove your case, put on your witnesses, show us your evidence, convince the jury, all 10 jurors sitting in that box, you convince them by the highest weight that there exists in the legal system that all of the offenses, all of the elements of the offenses were met. And we're not inclined or required to prove anything by our defense. And that's a true legal statement.
And we know all of them were charged with felonious assault. How does Ohio law differentiate between assault and felonious assault?
The 290313, no person shall knowingly cause or attempt to cause physical harm to another. That's assault. Assault is a first degree misdemeanor, looking up to 6 months in jail. Then we have different degrees. Some states have assault 1 and assault 2, assault 5. In Ohio, we have degrees of assault. So aggravated assault, negligent assault, felonious assault. And then there's a distinction between felonious assault and attempted murder. Again, the prosecutor has the discretion whether to advance a attempted murder charge versus a felonious assault charge. Felonious assault is essentially an assault. You got to prove somebody was causing physical harm to another, and either you cause serious physical harm to the person or you use a weapon during the course of committing that assault. And that's what takes it from a misdemeanor to a felony and increases those penalties exponentially.
If convicted of all charges, could any of the suspects face life in prison?
Not on these charges, not in actual life. Now, of course, if you get 30 years in prison and you're 55, it's essentially and technically a life sentence, but it's practically a life sentence, not technically. Technically, there is not a sentence of life available for these charges that have been brought here.
If during the course of the trial, the defense argues the victim had opportunities to leave but didn't, could that weaken the kidnapping charge?
It could. That would be somewhat of mitigation, and certainly there could be an argument that at different times he was not being held against his will, but the initial relocation under threat of force or using force, that's when the kidnapping gets established. How far and to what extent the kidnapping was engaged goes to the question of how severe of a penalty the persons are facing. I mean, what we know here is the reason that we even have this case, or we believe, is because at one point he escaped, got to a speedway, and was able to flag down some folks and get some help. Well, the kidnapping had already occurred at that point. So that fact that he was able to escape doesn't undo the charge that has already occurred prior to that time.
Can we expect the victim to take the stand in this case, or based on the evidence, can the prosecution build a case without his direct testimony? Or if he doesn't take the stand, will this case crumble?
In the majority of cases where there's a victim, and we're talking about domestic violence, we're talking about assault charge, we're talking about aggravated assault, or anything other than a murder charge, the victim is usually the linchpin of the charge itself. I mean, barring the fact that they perhaps are in a coma or because of the severity of the assault that was meted out on them are unable to provide testimony. The victim is the one that really makes the case. They identify the individuals involved. They talk about the motive behind it. They talk about, to a very emotional degree, the consequences and how they were impacted by the outrageous and egregious actions of the perpetrator. So most of the time, prosecutors do not move forward on cases if the victims do not appear or if the victim decides not to testify. Most of those cases are dismissed for what's called warrant of prosecution. Judge, we're not able to proceed because the victim refused to testify. Judge, we're not able to appear because the victim has disappeared and we don't know, we can't find them, because normally police have the evidence they have is the testimony of the victim. Sometimes you have a confession, but you still need a corpus delicti, you still need the body in order to establish that there was an offense that occurred. And so simply the confessed testimony, if you have it, of defendants is not sufficient in victim cases to obtain a conviction. So if the victim becomes uncooperative or perhaps disappears, it is very unlikely. Again, don't know what evidence they do have, but it is very unlikely that the case would proceed.
How likely is it that we'll skip a trial and the suspects will accept plea deals?
The majority of cases that we see in our system are resolved by pleas. It's the same in civil cases. Cases get filed, but cases get resolved. And majority of cases do. And the most egregious cases normally are resolved by plea because all parties recognize there is some value in negotiating an agreed outcome rather than leaving it up to the wiles of 10 people whose days you don't know and whose history or background or interest you're not aware of. So it's possible and very likely based on the percentage of cases that are actually resolved by pleas.
Great. Well, this is something that we will definitely be following. Thank you so much, Judge, for coming on today.
Thank you.
Court records show a judge set a $200,000 bond for each of them. For Law and Crime, I'm Kennedi Walker.